In just a few moments, a hearing will begin on President Donald Trump's executive order on immigration. A three-judge panel on the Ninth Circuit Court of Appeals will hear arguments on the case. This comes after attorneys general in Washington and Minnesota challenged the order, saying the ban had unleashed chaos in their states. We are going to have a jam-packed panel of lawyers and legal analysts to break this all down. We will bring in the few that we have here, and we're going to hope to get Paula Reed, our justice reporter in Washington, D.C. So joining me here in New York City is CBS News legal analyst Ricky Kleeman and attorney Carissa Krantz. And in Los Angeles, former U.S. Senior District Attorney and now practicing attorney Ron Bamier. Ron, good to see you. Ladies, thanks so much for being here.
Thank you.
Let's start with you, Ron. You've actually argued cases before the Ninth Circuit. What can we expect from these judges?
Well, the panel that they selected is a diverse group. There's three judges on there. They all come from different political spectrums, appointed by three different presidents. Really, it's kind of a wild card. Now, the question is how they're going to view this case. They're going to look at the law, or are there going to be some politics involved? If they go with the law, it's a pretty clear decision. The president is going to win. That executive order will go back in place, and they will overturn the district court's decision. If there's a political aspect to it, in my opinion, then the president may have some issues.
And Ron, just to follow up on that, I've heard that it's been said that the Ninth Circuit is one of the more liberal circuits in the country. Is that correct?
You can't get any farther left in the Ninth Circuit, yes.
Okay. All right, so let's bring in Ricky and Carissa to talk about this. So, Ricky, the question today is not on the order's constitutionality. You've been sort of hammering that. Explain what's actually going to happen.
Most of the press has looked at this as if this hearing before this three-judge panel of the Ninth Circuit is going to say whether or not the executive order is constitutional or not. That is not what they're here to do. What they're here to do is really very narrow. Judge Robart last week issued an order called a temporary restraining order, or what the lawyers would call a TRO. That's a temporary suspension of the use of the executive order until the entire case, including the constitutionality, could be heard on the merits. This three-judge panel is really there to decide, do they extend that TRO, that is that temporary restraining order, while the litigation goes forward? Or do they say, no, the TRO was erroneous, and that we think that although the litigation is going to go forward, the executive order goes back in effect? Now, I'm agreeing with Ron because I'm telling you the law as it should be in its most narrow construction. However, with this situation, things are not always narrow.
It's interesting. One of the things I find really fascinating about this, Carissa, is the Attorney General in Washington State is suing, according to the brief, on behalf of the people in Washington State. What's interesting is he didn't even ask the judge to extend this injunction to people who have never been in the country, people who've never set foot in the country, but he did. He made this a global injunction. Why did he go beyond what was asked by the Attorney General?
You know, I think one thing that's actually really interesting is they're going back sort of on the executive order and making it more broad to be more favorable to Trump in saying that the executive order won't apply to people that are already permanent residents, which it's interesting because, as it was just stated, the Ninth Circuit is, generally a liberal court. But it really could go either way, and there's a whole lot. It's totally up in the air.
Right.
Three different things could happen tonight.
Yeah, I mean, I think, Ron, let me toss this to you. I mean, so the Attorney General in Washington has said that he doesn't think it's constitutional what the president is trying to do here. But as it applies to a family, for example, that's in Yemen, that has never set foot in the United States, that wants to apply for a visa, that has no constitutional right to be in the United States, how is this regulation unconstitutional as it applies to that family?
It's not, because just like if you were in Yemen and you were held by authorities in Yemen and you said, wait, I have constitutional rights, you can't hold me, and they would sit there and laugh at you and say, you're in Yemen, you have no rights. Well, the U.S. gets to do the same thing for somebody from Yemen. You're in Yemen, you have no rights in America yet. Until you're a resident of the country or in the country legally, you have no rights, basically. There are exceptions, of course, but there is no constitutional standing for a citizen of Yemen. By the way, the other panelist who said that what they're determining is whether the judge in Washington State abuses discretion. And to do that, they can look at and say if he was overbroad in his ruling. And so eventually what's going to happen, and what should happen, is the court should say, you're way overbroad in this area. You've really exceeded your discretion, you've abused it, and it should be overturned.
So Ricky, Ron brings up an interesting point about standing. And I think a lot of our viewers will want to know, why is it that this judge in Washington found that there was merit to what the Attorney General was putting forth, and in Massachusetts, they did not?
Well, Massachusetts really is a different case. I know people have looked at them as one side and the other, but they really are different. Here, the judge in Massachusetts, there also was an earlier order. The judge in Massachusetts, Judge Gorton, decided not to extend the earlier order and wrote a 21-page opinion, which I think is very favorable in the end to the administration. What Ron is saying, and I completely agree with him, is that here, if you follow my thought, Ron's thought, which is if you're a strict constructionist as a judge, you look at this as a very narrow possibility. Did the judge abuse his discretion below when he issued this TRO, or should it be continued? And if so, why? So one of the reasons of why really has to do with the question of damages. So it goes back to your question, which is standing. The state of Washington and the state of Minnesota, which joined, and now you have all kinds of other states that have filed amicus briefs. You have law professors who have filed amicus briefs. You have affidavits and briefs from tech companies, universities, and others. What they're all saying is the same thing. They are saying, look, we cannot recruit people. We cannot keep people. Our business is being hurt. Ultimately, the claim is that hurts economically and otherwise the state of Washington and the state of Minnesota, which are litigants. Now, do I expect that the standing issue, could Washington and Minnesota sue, to be argued in the next hour? I certainly do.
All right, that's something we're going to be talking about. Each party will have 30 minutes to make their case. It's going to begin at about 6 p.m. Eastern Time. We're going to take a quick break. We're going to be back on the other side of it with a whole lot more analysis from our panel. Stay with us. You're watching CBSN. Welcome back to CBSN. We are just moments away, about 5 minutes away, give or take, from that live shot that you're looking at right now in San Francisco, where we expect the United States government and the plaintiffs in this case, the state of Washington, Minnesota, to make their case as to President Trump's executive order, what many people have called, including the president himself, a travel ban. We're going to hear those arguments in about 5 minutes. We're joined by Ron Bame. He is joining us remotely, and here in New York City, we've got attorneys Ricky Kleeman and Carissa Krantz. All right, so each party will have 30 minutes, Carissa, to make their case in the next 5 minutes or so. Explain what's going to go down. How's it going to go down?
Well, there's a couple different scenarios that can happen. I see three main scenarios that can happen. The first one is that this could become a political decision, and the Ninth Circuit is going to, which is generally a liberal court, is going to rule in favor of the district court in upholding the temporary restraining order and treat it like a temporary injunction. Or they could say that, you know, there should be that the government has plenary power to run foreign affairs and national security and immigration the way they would like to, and that the president's decision should stand and that the court should not get involved. Or they could say, you know what, a temporary restraining order is not a temporary injunction, and return this back to the district court and allow the district court to continue its briefing, which is right now up until February 17th, and then a hearing will be on the briefing for the injunction, and then decide whether or not a temporary injunction is really on the table. Because right now it's a temporary restraining order, which is different, but the court seems to be treating it like a temporary injunction, even though it is a restraining order. But in theory, restraining orders really aren't supposed to be appealed unless there's an interlocutory order. So it appears, though, we'll see what happens. There's just so many scenarios that could happen. It could be a political decision, it could be a court decision, or it could be returned back.
Let me actually, this is supposedly going to start in just a few minutes. I want to get Ron before I go to Ricky. Ron, Carissa just mentioned the politics here. If we were able to get in Doc Brown's time machine and we were able to go back, to a couple of weeks ago when this order was being drafted, because there are many Americans who think that President Trump is on the right track in the sense that he wants to keep Americans safe. All presidents do, but there's a lot of people that have found problems with the way that this was worded, the way that this was implemented. What would you have done differently?
Well, it's not what you would have done differently. I guess the way the executive order is crafted, it follows the law. It follows the immigration law. It cites the president's powers to basically protect the country. It cites the president's powers to decide and ban people who he think could be a danger to the United States, and it follows the law that Reagan applied when he banned the Cubans, and when Carter applied when he banned the Iranians. Same type of theory, same type of language.
Ron, stand by just one moment, because I think we're having some problems with your audio. I thought it was maybe just me going deaf, which is happening at my age, but it's apparently not. It's a technical audio issue. So, Ricky, let me ask you that question. If you were able to go back and look at the way that this order was drafted, what would you have done differently?
Well, I think it's not only a drafting problem, it's a roll-up problem. It's
right.
The optics. We have to remember that the 7 named countries were countries that were identified under the Obama administration as being areas where terrorism is occurring or where the making of jihadists is occurring. President Trump and his people did not pick these 7 countries out of the air. They were already written down during the Obama administration. So I think that there was a way to come forward with it publicly, to be able to say why they chose those 7 countries. What's the real purpose of looking at 90 days? What's the purpose of looking at 120 days? What happened instead was it got rolled out at a very odd hour without much explanation or any at all, and people reacted the way you would expect many people to react, which is to say that it was a Muslim ban
right.
on the basis of rhetoric that had been stated by the president when he was the president-elect and afterwards, and by his representatives or his colleagues, including Rudy Giuliani, who went forward and talked about the fact that he was instructed to create a legal Muslim ban. So I do think it's more about the optics than it is necessarily about the drafting. But you're asking the question also creates another question. Why can't they just redraft it?
Right.
Why can't they take a pause, let temperatures cool, redraft it, bring it out in another way? And the reason is they can, but they won't.
Ron, I think if we have your audio back, or at least I will be able to hear you now. You heard what Ricky had to say about that. And I'm curious, one of the things that the Attorney General in Washington, Attorney General Ferguson, has said is that he believes this executive order is unconstitutional, full stop. What's your take on that?
It's not. It's been done before. It's been done by other presidents throughout time. The immigration law allows the president to do this. Congress has given this power to the president already. So what is unconstitutional is a federal judge in Washington getting involved in national security issues.
So, Ron,
that's what's unconstitutional.
Just so I understand and our viewers understand, it was my impression that the Congress has authority over immigration, the president, national security, but you're saying that the president does have, by the basis of the Constitution, the ability to I don't want to use the word regulate, but regulate immigration.
No, by the basis of the Congress giving him that power through a law,
right.
He has that power. And that's where it comes from.
So then, at the end of the day, if this court comes back and they say to the government, look, we're standing with Washington, Minnesota, Carissa, what does the government then do?
Well, most likely this is going to go on appeal no matter what happens
today. No matter what
today.
happens, right.
And the next step is probably going to be an en banc hearing with the Ninth Circuit, and then it's going to go up to the U.S. Supreme Court. And depending on what happens at the Ninth Circuit, the Supreme Court will hear the case. And it's important to note that the Supreme Court is understaffed right now. So if it is a deadlock and it is a 4-4 decision, whatever the Ninth Circuit decides will stand.
Oh, that's interesting. So because they have not yet, we have the president has put forth a nominee, but he hasn't been confirmed, he hasn't been voted on. If they deadlock, it goes back to the Ninth Circuit.
The Ninth Circuit's decision will stand.
Will stand.
Yeah.
Interesting.
And you're also dealing with, Vlad, you're dealing with the fact of whether or not the United States Supreme Court takes the case.
Right.
So these cases, If they go to an en banc hearing, I would expect that if you have these three judges, should they decide in favor, I got your signal, we
Ricky,
must be starting.
They are indeed starting. We want to take our viewers now. This is happening live right now. It's being live streamed. The travel ban appeals hearing, the state of Washington versus the President of the United States, Donald Trump. Let's go ahead and listen in.
Also on the line. We thank you, counsel, for your very helpful briefing and for appearing today on short notice. As you have heard, you'll each have 30 minutes, and I will try to help you with your time because I know you can't see a timer like you would in the courtroom, but if you could also please try to watch the time yourselves, that would be great. With that, we will hear first from the government. Mr. Flengy, please proceed.
May it please the court. I'm August Flengy with the Justice Department here on behalf of the United States. I'd like to reserve 5 minutes for rebuttal. The executive order at issue puts a temporary pause on entry for individuals from 7 countries that Congress and the last president determined in a similar context pose special risks in terms of terrorist infiltration into our country. Those determinations were made in 2015 and 2016 based either on a congressional determination or statutory factors including their foreign terrorist organizations had significant presence in the country, or the country served as a safe haven for terrorists. The order also temporarily halted refugee program. This judgment was well within the president's power as delegated to him by Congress, and it is constitutional as the court in Boston in the Halal Kalam recently held. Under Section 212F, Congress has expressly authorized the president to suspend entry of classes of aliens when it is necessary or when otherwise it would be detrimental to the interests of the United States. That's what the president did here. And the president's determination that a 90-day pause was needed for the 7 countries at issue here in order to ensure adequate standards, and that's language from the order, for visa screening was plainly constitutional. The district's court's order, which contained no assessment of the legality of the order, was in error, and we encourage the court to stay. A key factor in the order and its temporary nature was the president's determination that there was a need to review existing practices for screening foreign nationals who apply for visas.
This is
the order
if I can interrupt for a moment. You're asking for a stay of the temporary order of the district court. No matter which way we rule on your stay, presumably that appeal of the order remains in place. Is that correct? Or are you trying? Sometimes I get the impression from the papers that we're trying to argue the merits of the appeal itself rather than the merits of the stay.
Yes, Your Honor. There is some overlap, but yes, we are at this point just asking for a stay pending review by this court. Of course, the standards are pretty similar since both would look at the traditional injunction standards. With respect to those standards, I do want to say there are 2 kind of significant irreparable injuries that we are citing in support of our request for a stay. The first irreparable injury has to do with the assessment of risk that the president made in balancing our interest in welcoming people into this country with our interest in making sure our procedures are secure so that the risk of terrorism is acceptable. The president struck that balance, and the district court's order has upset that balance. This is a traditional national security judgment that is assigned to the political branches and the president, and the court's order immediately altered that.
Have you offered any evidence to support this need that you're describing for the executive order, or are you really arguing that we can't even ask about whether there's evidence because this decision is not reviewable?
Sure. The order itself includes findings. Those findings recognize the crucial role that screening presents in in the visa process. They recognize that numerous foreign-born individuals have been convicted or implicated in crimes since September 11th. It recognizes that deteriorating conditions in certain countries create further problems. So the order created a pause so that the screening process could immediately be reviewed to ensure it's adequate.
Has the government pointed to any evidence connecting these countries with terrorism?
These proceedings have been moving very fast. The strongest point on that is that in 2015 and 2016, both Congress and the administration made determinations that these 7 countries posed the greatest risk of terrorism, and in doing so restricted visa waiver to people who had even traveled to those countries over the last 5 or 6 years. The executive order relies on that determination, and that is, I think, the strongest type of reliance, where the president is relying on Congress's determination that these are countries of concern, and Congress's procedures to identify countries of concern based on significant terrorist activity in the countries.
This is Judge Clifton. I understand the concept of that, but it's pretty abstract, and it's not like there haven't been processes in place to take some care with people coming from those countries. Indeed, those are the determinations in the statute and by the prior administration you're pointing to. Is there any reason for us to think that there's a real risk, or that circumstances have changed such that there would be a real risk if existing procedures weren't allowed to stay in place while the new administration conducts its review?
Well, the president determined that there was a real risk. That's why the president determined that the best course was a temporary, it's a short halt in entry for 90 days while these procedures are looked at, and that's understandable. The president comes into office with an obligation to protect the national security of our country. The president understands, and it explains in the order, that these visa screening procedures are crucial. And the president understands that Congress identified these 7 countries, as well as in 2016, the president.
This is Judge Canby. Of course, in naming those 7 countries, what Congress did was to provide that people coming from those countries had to get visas. In other words, they couldn't just come into the country without a visa. And that permitted, of course, the usual investigations before you give somebody a visa. And in the transcript of the hearing in the district court asks the representative of the Department of Justice, you're in the Department of Justice, how many federal offenses have we had being committed by people who came in with visas from these countries? And the ultimate was, the answer was, there haven't been any.
Yes, Your Honor. These proceedings have been moving quite fast, and we're doing the best we can. I can
You're
cite...
saying that the proceedings are moving fast, but you appealed to us before you continued in the district court to develop the record. So why should we be hearing this now if it sounds like you're trying to say you're going to present other evidence later?
Well, I was just about to at least mention a few examples. There have been a number of people from Somalia connected to al-Shabaab who have been convicted in the United States.
Is that in the record? Can you point us to where in the record you're referring?
It is not in the record. There has also been other examples, but again, you're correct. These are not in the record. The reason we sought immediate relief and a stay is because of the district court's decision overrides the president's national security judgment about the level of risk, and we've been talking about the level of risk that is acceptable. as soon as we are having that discussion, it should be acknowledged that the president is the official that is charged with making those judgments. I'd also like to
So are we back
talk briefly.
are you arguing then that the president's decision in that regard is unreviewable?
Yes, there are obviously constitutional limitations, but we're discussing the risk assessment.
What are the constitutional limitations that the government acknowledges?
I would more say that the plaintiff has asserted various constitutional limitations. And I think the case that is most on point as far as constitutional interests are Mandel and Din. And in those cases where you have a U.S. citizen raising a claim, the court looks only at the U.S. citizen's constitutional claim, and even then looks at whether the decision is facially legitimate and bona fide. The executive order here meets that standard easily. It relies on...
In both of those cases, though, specific statutes by Congress that set forth specific criteria that were then applied factually were at issue. The president is not applying any specific criteria from Congress here, is he?
Yes, the president is. The president is applying Section 212F, which authorizes the president to suspend entry of classes of aliens if their entry would be, quote, detrimental to the interests of the United States. It now, the Supreme Court recognized that Congress and the president share the act of exclusion of aliens is a fundamental act of sovereignty that the Congress and the president they're within the powers of Congress and the president. So our point would be that there's limited review, and the executive order, at most limited review, and the executive order easily passes that test. And that would only be true if there's a
review. What kind of limited review do you acknowledge is appropriate?
Again, we're not acknowledging any review on the facts of this case because of a lot of standing and other problems with the state bringing the claim. What we acknowledge is that Mandel conducted a limited review to see that the decision was bona fide and legitimate.
Haven't there been allegations here of bad faith? And doesn't Mandel and Din, the concurrence in Din, envision that that's something that we would need to look at?
When reviewing executive order of the president under Section 212F, the review should be confined to the four corners of the document to determine if the decision itself and the executive order's findings have any issues with respect to the standard. And again, I'm sort of far ahead of our position. This would be if there is a party in the U.S. with standing to raise their own constitutional claims, and there are problems at each step of that analysis. The state of Washington doesn't have these kind of constitutional interests. The state of Washington can't bring a parens patriae suit on behalf of its citizens in this context. And
let me interrupt you for a second there. There's some talk in the Supreme Court cases of quasi-sovereign interests. And for instance, a state might have an interest in clean air. And when it sues to protect its air, it's necessarily acting for its citizens. The state itself can't smell air, it can't see air. It has to be acting on behalf of its citizens when it brings a case like that, yet there seems to be authority for the state to bring that kind of a claim.
Well, the problem in the immigration context, and actually more generally, is a third party can't challenge visa denials or revocations. The claims that the state is bringing are essential.
Sure they can. Look, I mean, the whole point of the Din case was that Din himself, or rather Din's husband, couldn't challenge, but she could. And 3 justices of the court were prepared to throw it out at the first step, but the other 6 justices were not. They took up the claim. Why isn't the state of Washington in a comparable position, say, as the proprietor of the state universities, having the same kind of interest that the scholar plaintiffs did in Mandel?
Well, the problem is because the state's asserting a parens patriae theory, where
that's not the only
Well, they're
theory.
also asserting
They've
their
other
own interests
theories.
as proprietors of the university and otherwise. Tax revenues?
Yes, but let me finish with the first theory, and then I'll get to that. The parens patriae theory assumes you're asserting the rights on behalf of the beneficiary, but there's well-established law that in the immigration context, the sort of third-party interest, and the case O'Bannon describes this, is not something that can be asserted. I'd also
I suggest that Kerry versus Din asserts exactly that. I mean, in Kerry versus Din, the plaintiff, Din, was the wife of the person who was excluded. So the person who was excluded may not have had any rights that he could assert directly, but his wife was allowed to.
And the state doesn't have the sort of constitutional rights that the wife in Din had. The wife in Din was asserting her own.
No, why isn't the state's right the same as the scholars in Mandel? Mandel was a foreigner. He might not have had rights, but the court took the case up because the people who argued they wanted to be able to hear him, the various universities to which he'd been invited. Well, the University of Washington, Washington State invite people. Why doesn't the state of Washington have the same standing that the scholars did in Mandel?
Again, you have to look at sort of the right of the state, and I guess I was discussing the right of the state on behalf of the people that it's bringing suit on behalf of. It's sort of collapsing the inquiry.
Well, I understand you're moving away, or I'm dragging you away from the parens patriae theory. Just speaking for myself, I agree with you on that. The state can't do that. But the state has also asserted a proprietary interest, in particular as the owner and operator of the universities. And it seems to me they line up very much as the way the plaintiffs in Mandel did.
Well, on that point, our claim is that it doesn't have a judicially cognizable or legally protected interest in third-party immigration benefits. The statutory
that's exactly
scheme,
the same case that was raised in Kerry versus Din, and the majority of the court didn't say that. That was an immigration case. Mandel was an immigration case, both involving visa denials, and yet the court took them up.
Sure. Then we have to talk about what the constitutional interest of the state entity is. And it's well established that there's no due process.
Let me stop you there. Why is it limited to the state entry? I mean, in Din, she wasn't asserting her own rights; she was asserting her husband's rights. In Mandel,
no, she was asserting her. Sorry, Your Honor.
It was her right as the wife, claiming the loss of consortium and so forth. But the visa denial was to her husband. In this case, the state of Washington is claiming that it's going to hurt the university if it's not able to have these people come to the university. That sounds very much like the same kind of right that was asserted in Mandel.
Well, hurting the university isn't enough now that we've turned on to the actual challenge. The state has to have a constitutional interest, because in Din it was the constitutional interest of the U.S. citizen spouse that the court was looking at. And if you get behind...
So what was the constitutional interest in Pierce versus Society of Sisters, where the school was allowed to assert the rights of the students and their families?
That was a case where, if I remember correctly, the university was acting on behalf challenging a state law that affected its students. there you would have constitutional interests for the students at the school. Here, aliens would not. I do want to turn to a very
isn't that the merits question? So why can't we reach the merits question through the third-party standing asserted by the universities and the states here? The universities are part of the states.
Well, I think it all gets tied up together a little bit because of the well-established authority that a state entity can't assert these kind of rights. And even on the merits, I would like to point out that the executive order relied on the congressional and administrative determination of years ago of 2015 and 2016. So it's not an order that discriminates in a way on the basis of religion, and there would not be a valid equal protection. I do want to, before I run out of time, oh, go ahead.
No, that's all right. Could the president simply say in the order, we're not going to let any Muslims in?
That's not what the order does here.
Oh, I know.
And the order relies on... Sorry, Your Honor.
Could he do that? Could he do that?
That's not what the order does.
Would anybody be able to challenge that?
That's not what the order does here. I do really feel, I do want to get to one key point.
Well, we'd like to get to an answer to that question, because it speaks back to the standing issue. If the order said Muslims cannot be admitted, would anybody have standing to challenge that?
I think Mandel and Din give a route to make a constitutional challenge if there were such an order. It would be by a U.S. citizen with a connection to someone seeking entry. This is a far cry from that situation. I'm not sure I'm...
Is there a purpose in standing doctrine? I mean, standing is supposed to ensure adversity. Is there any purpose for your argument that we shouldn't recognize this lawsuit by the states and we should instead wait for an individual to bring the same claims? What's the purpose of that?
Well, there needs to be a concrete, legally protected interest that's judicially cognizable. And the people, I mean, across the country, there are many lawsuits where there clearly is standing. There are people impacted by this order, and there are cases across the country where we don't have these type of standing arguments. But in this case, there's a lot of law that says states can't step into the shoes of their citizens in this context. We have the sort of proprietary interests are very diffuse, and if we credit them, there would be almost no limitations on standing. I think in that context, it doesn't make sense to extend standing jurisprudence to cover this kind of situation. But I'm not sure I'm convincing the court, so I want to make one really key point with regard to the injunction, and that is that it is overbroad and should be immediately stayed to the extent it is overbroad, even if the court thinks some applications of the order are problematic. The state has admitted that people abroad without prior U.S. contacts do not have rights that can be asserted by them, and we agree. In the district court, the state said our claim is primarily focused on the people who are here or who have been here and left. And on appeal, the states went further, explaining, quote, this case, by contrast to cases on entry, involves longtime residents who are here and have constitutional rights, end quote. That is the nature of the state's claim. The injunction goes far beyond that.
The states are claiming that the executive order violates the Establishment Clause. If that's true, and it can't meet the standards that the Establishment Clause would impose, then wouldn't it be invalid on its face?
Your Honor, the state has said that their case, quote, involves longtime residents who are here and have constitutional rights, end quote. That is from their brief at page 10.
But if some of those rights are Establishment Clause rights, then can't an Establishment Clause claim be made by one individual and invalidate the whole thing? I'm not sure why that's responsive.
The scope of the injunction, whether it's nationwide or anything else, should be limited to the scope of what the state itself says it is kind of representing through its various theories of standing. But issuing a broader injunction violates the principle that an injunction should only be as extensive as is necessary to fully remedy the claims of the parties.
This is Judge Canby. Don't any of the declarations indicate that the state universities invite foreign scholars to come to the state, make presentations, come for a time, go back, and that they wanted to continue doing that, which means there probably would be future invitations to scholars who do not yet have a connection with this country.
I believe there are some declarations along those lines, but I am describing the actual statement of the extent of their suit that they made in the brief to this court. And to the extent that is the relief they seek, this court should immediately stay the relief that extends broader, and that is to people who have never been to the United States. And Section 5 of the order, which is the refugee provision and applies to people who haven't been here yet and don't have those relations with the university and don't quote involve longtime residents who are here and have constitutional rights. I'm into my rebuttal time, but I would strongly encourage the court, even if it has concerns with the government's position, that it immediately stay the portion of the injunction that applies outside the boundaries of the U.S. And extends beyond people who are in the U.S. or who have been in the U.S. Thank you.
Thank you. Mr. Purcell?
Yes, Your Honor. May it please the court. I'm Washington State Solicitor General Noah Purcell on behalf of the states of Washington and Minnesota. Your Honors, it has always been the judicial branch's role to say what the law is and to serve as a check on abuses by the executive branch. That judicial role has never been more important in recent memory than it is today. But the President is asking this court to abdicate that role here, to reinstate the executive order without meaningful judicial review, and to throw this country back into chaos. The court should decline that invitation. This afternoon, I'd like to first discuss why the court should reject defendant's motion on jurisdictional grounds, and then explain why, even if the court does consider the motion, the court should reject it on the merits. So, starting with appealability, defendants have pursued the wrong remedy by seeking a stay in this court rather than mandamus. Of course, so defendants have filed a notice of appeal and then a motion for stay pending appeal.
This is Judge Clifton. Why should we care?
Yeah.
I mean,
well,
is it your position a district court, suppose a district court issued an order requiring all the public schools in the state of Washington to be closed because of some concern about a flu epidemic, and did it in the form of a TRO and said the TRO would only last less than 14 days. Are you suggesting mandamus is the only form of relief available?
Well, Your Honor, I first want to answer why you should care, if you don't mind, before, because I do think it makes a big difference for two reasons.
You're basically saying we shouldn't look at it, and it's hard to me to envision an order this sweeping that shouldn't be subject to some kind of appellate oversight.
Your Honor, I'm not at all saying that you shouldn't look at it. Not at all.
You've got a TRO that, by its terms, I mean, we've now received the proposed schedule, and the district court has entered an order, so we know already that this TRO is going to stay in place for more than the 14 days contemplated by Rule 65. So why shouldn't we view this as an injunction?
Well, for several reasons, Your Honor. First of all, in the cases where this court has treated a TRO as an injunction, the timeline of the order was vastly longer. In the SEIU case that the defendants have cited, the order lasted 4 months. Here, the order will be the district court explicitly called the order a temporary restraining order, ordered a very quick, ordered the parties to confer and agree on a briefing schedule, and briefing will be complete within 14 days of the entry of the order. It could have been completed faster if the government hadn't filed this appeal and forced us to spend quite so much time on this. And the judge, I'm sure...
Time today as you want, but I'd suggest that this might not be the topic that's most important. But
fair enough, Your Honor. I would just say The only point I'd make is that mandamus does allow review. It's just an extremely strict standard. And the important point also is that if the court treats this as an appealable order, then that's what the ultimate appeal of the ultimate ruling will be of. Whereas if the court properly treats this as a mandamus decision and sends it back to the district court will have the opportunity to enter a more full preliminary injunction when the district court understands that that's what it's doing, when that's its intent. And that will be what the court can ultimately review, as opposed to reviewing what the court clearly intended to be a temporary restraining order.
Yes, Judge Canby, in your view, if we left this order in place, would there then be a preliminary injunction hearing in the district court?
Absolutely, Your Honor. Absolutely. The parties have agreed to a briefing schedule. The preliminary injunction motion will be fully briefed by a week from Friday. I'm confident that Judge Robart will schedule a hearing and rule quickly after that. I'd also point out that the 14-day limit is for ex parte temporary restraining orders by its text. This one, part of the problem with treating this as a temporary restraining order, Your Honor, is that if the defendants are right that any time the court enters a temporary restraining order after a hearing and receiving briefing, it's treated as a preliminary injunction. That's a terrible rule to create for district courts, because it discourages them from hearing from the other side before entering a temporary restraining order. But Your Honors, I do certainly want to move on to the merits. I don't want to spend all your time on this. And of course, if this is treated as a motion for stay, we obviously still believe that the court should reject that motion. And the most simple basis for that, of course, would be the lack of irreparable harm. I heard Your Honors again pressing counsel for a statement of what the irreparable harm is, and still no clear factual claims or evidentiary claims of what that irreparable harm would be from a stay. And in fact, it was the executive order itself that caused irreparable harm to our states, to Washington and Minnesota and our residents, and to many other states and people, as described in the many amicus briefs that have been filed. So of course, we believe that the federal government has shown no irreparable harm from reinstating the status quo prior to the executive order.
What's the irreparable harm to the state of Washington?
From the executive order? Well, we detailed a number of irreparable harms, Your Honor. We had students and faculty at our state universities who were stranded overseas. We had families that were separated. We had longtime residents who could not travel overseas to visit their families without knowing that they would be able to come back. We had lost tax revenue. We had...
If we don't agree with your parents' patriae theory, then in balancing the harms and thinking about the standards for a stay or for a TRO, are we limited to looking at the proprietary interests of the state itself? Or can we look beyond that, even if we reject the parents' patriae theory? Or do you need the parents' patriae theory to expand the harms that we can consider?
I don't think the parents' patriae theory is essential, Your Honor. We've argued two independent grounds for standing. One, the proprietary harms that we're suffering, and one, the parents' patriae. So the court could certainly choose.
Say we agree with the proprietary theory for standing. Does that have any implications for what we can then consider when considering the factors for a TRO and for a stay? Or is it just a way to get standing and then we can consider anything in the public interest that affects the public interest?
I think it would primarily just go to standing, Your Honor, because I think the harms, well, I mean, maybe you would then consider the harms, the other harms in the balancing of equities and the public interest factor of the test, I suppose, as opposed to in the standing test, but certainly those harms would not become irrelevant. And again, it's now, at this point, it's really the federal government that's asking the court to upset the status quo. Things have slowly gone, are returning to normal, to the situation before the chaos of the executive order, and it's the federal government that's asking the court to upend that status quo again. And Your Honor, I think it's fair. Counsel for the government repeatedly sort of tried to limit the nature of our claim by quoting from our brief, and I think that misrepresents our claims to some extent in a way that's important, because the point we're making in the brief there about longtime residents is that this case is different from Mandel and Din in an important way, in that the federal actions here affect longtime residents who have been here. Now, that's not all it affects. It also affects people who are trying to visit them. It affects those people trying to visit their families. The Establishment Clause violation affects everyone in a sense, in the sense that well, as the court knows, the case law is quite clear that Establishment Clause violations on their own show irreparable injury, and we of course believe that that claim is very strong. So just on the merits, the state has shown a strong likelihood of success. The federal government certainly, the states, I'm sorry, have shown a strong likelihood of success, and the federal government certainly hasn't met its burden on review of showing a likelihood of overcoming that showing.
Judge Canby, as far as the Establishment Clause claim goes, the government takes a position, I think, that in weighing the validity of your Establishment Clause claim, you're confined to the four corners of the instrument. What's your comment on that?
Your Honor, I think the case law shows that that's wrong. I think it was Judge Clifton who pointed out, or Judge Friedland, I'm sorry, or maybe both. Kerry versus Din says exactly the opposite. This court's decision in Cardenas says exactly the opposite, that if the plaintiff makes plausible allegations sufficiently supported of bad faith, the court can look behind the motives. And in those cases, just to be clear, those were cases where the case had to do with excluding an alien who had never been here and had no right to be here. So if anything, the court should take a harder look at the real motives in a case where there are significant impacts on people who do live here, who've been here for many years, who are longtime residents and who clearly are entitled themselves to constitutional rights of due process and equal protection, unlike in Kerry and Mandel, where really it was the rights being harmed were of the people overseas. It was the people here who were asserting them.
Well, we should be very careful about that. The assertion that the court took up the claim only because, in the case of Kerry versus Din, Ms. Din was a U.S. citizen. Of the number of people affected by the executive order, do you have any information as to what proportion would fit within the category of Washington residents or lawful permanent residents or people with visas? I mean, I suspect it's a small fraction.
I'd make 2 points on that, Your Honor. First of all, we are at the pleading stage. We have not had an opportunity. We filed a complaint and a motion for temporary restraining order, and so for standing purposes, all the plausible allegations in our complaint are treated as true. Now, we've alleged that there are thousands of people in Washington, thousands more in Minnesota, who are originally from these countries who are not yet citizens here. We know the way the order was originally interpreted, excuse me, Your Honor, defendants originally interpreted the order and said that it covered lawful permanent residents. We know that there are roughly 500,000 lawful permanent residents from these 7 countries in the United States. Now, they've changed their mind about 5 times about whether it applies to those people in the time since the order issued, and now they say that it doesn't. But at the time the state filed its complaint, they had not yet made their position clear about that, and I would say that that argument is not moot yet, because under the voluntary cessation standard, until they change the order to make that crystal clear, that claim, they can't just say, well, now we say it doesn't apply to them, so don't worry about it. I mean, that's 500,000 people who are in the United States who overnight, at least according to the government initially, lost their right to travel, to come in and out of the country, to visit their relatives. And several people...
Why shouldn't we limit the order, the temporary restraining order, reach to those people who you've got a strong case for, like the LPRs? Why should the temporary restraining order reach beyond that? That seemed to be the government's principal argument, that it was overbroad. Why isn't it overbroad?
For 3 key reasons, Your Honor. First of all, limiting the order in that way would not address all the harms the order is causing. So, for example, it would not remedy the order's violation of the Establishment Clause, which harms everyone in our states, as well as our states themselves, by favoring one religious group over another. It also would not fully remedy the order's violation of the Equal Protection Clause because the order relies on discriminatory animus to deny some of our residents who are here the ability to receive visits from their friends and family while allowing others to receive those visits and so on. So it wouldn't address all the harms. The second point is that our U.S., as in DIN, the U.S. citizens who are here who are related to these folks overseas do have rights, and it would not address their rights at all to limit it that way. And then finally, Your Honor, I just say that defendants have not explained how they would workably implement the narrower order that they're now proposing, which they didn't really propose in any way before. Their approach would require some sort of system for quickly approving travel and reentry by thousands of people from the affected countries who live here, who study here, who work here in our businesses, and who often have to travel for work or to visit family. And they just have not credibly described how they would be able to do that, even if it were able to address all of our harms.
In evaluating your Establishment Clause claim, should we apply Larson or Lemon?
Well, Your Honor, we think we prevail under either test, but we think this case is closer to Larson because in Larson, what you had was a facially neutral law. It did not mention any religious denomination by name, but it did focus on religious groups, and the result of it was to distinguish between them in a way that favored some and not others. And that's exactly what we have here. We have an order that on its face doesn't mention any denomination, but that we have alleged, and there is strong evidence already to support, is intended to favor some religious groups over others. And that is exactly the situation in Larson. Now, I know the other side is saying if it doesn't mention a particular denomination on the face of the document, then Larson doesn't apply. But that's not what Larson itself says. In Larson, the law did not mention a denomination. But again, we also think that we prevail under the Lemon test, which is explained in some detail in our district court briefing. We did not, unfortunately, have space really to explain that argument as well in the briefing to this court.
If we were to agree with you about Larson, is there any reason to consider your equal protection claim, or are those two claims essentially redundant?
I think if you agreed with us about Larson, there would not be any need to reach our equal protection claim. I think that's fair.
Well, let me ask about the, I'll call this religious discrimination claim to reach both the equal protection and establishment clause claims. And I'm not entirely persuaded by the argument, if only because the 7 countries encompass only I think a relatively small percentage of Muslims. I mean, do you have any information as to what percentage or what proportion of the adherents to Islam worldwide are citizens or residents of those countries? My quick penciling suggests it's something less than 15%.
I have not done that math, Your Honor, but to be clear...
And given that all those countries are countries that have been previously tagged as subjects of concern about terrorism, granted, it's because of perhaps radical Islam sects, so there might be a religious motivation behind the terrorism, but I have trouble understanding why we're supposed to infer religious animus when, in fact, the vast majority of Muslims would not be affected as residents of those nations, and where the concern for terrorism with those connected with radical Islamic sects is kind of hard to deny.
Your Honor, the case law from this court and the Supreme Court is very clear that to prove religious discrimination, we do not need to prove that this order harms only Muslims or that it harms every Muslim. We just need to prove that it was motivated in part by a desire to harm Muslims. And we have alleged that... How
do you infer that desire if, in fact, the vast majority of Muslims are unaffected?
Well, Your Honor, in part, you can infer it from intent evidence. I mean, there are statements that we've quoted in our complaint that are rather shocking evidence of intent to discriminate against Muslims, given that we haven't even had any discovery yet to find out what else might have been said in private. I mean, the public statements from the president and his top advisors reflecting that intent are strong evidence, certainly at this pleading stage, to allow us to go forward on that claim. And again, you know, with no type of discrimination claim requires you to show that every single person of that category was harmed by the action. You just have to show that the action was motivated in part by a desire to harm that group. And that's exactly what we've alleged.
Any situation where the proportion affected were less than 15%?
Your Honor, I'm sorry. I haven't thought about. As I said, I had not done that math before the argument. I have not thought about the case in those terms because.
Well, let me switch to the other part of it. I mean, do you deny that in fact there is concern about people coming from those countries, separate and apart from what their religion might be, because as Congress and the previous administration have concluded, those countries are a concern from a terrorist perspective?
Your Honor, Congress had determined that those, and the executive had determined that those countries, as I think it was you who put it, should not, get a waiver from a visa requirement. That is eminently different from a complete ban on travel to this country.
Do you assert that decision by the previous administration or by Congress was religiously motivated?
No, Your Honor. No, we are not asserting that at all.
So it would be possible to identify these countries as a source of concern and possibly as the subject of special treatment without having religious motivation or discriminatory intent behind it.
Well, Your Honor, but cases like McCreary from the U.S. Supreme Court make very clear that in assessing Establishment Clause claims, an action that could have been perfectly legitimate if done with proper intent is not legitimate and is unconstitutional if done with a desire to favor one religion over another. McCreary makes that very clear. It literally says the exact same action could be acceptable if done for some reasons and not acceptable if done for others. And here we've alleged very plausibly with great detail that this was done to favor one religious group over another. And so we should be allowed to go forward on that claim, even though, yes, we're not denying that these countries could have theoretically and in fact were previously chosen for some lesser level.
It's not just your allegation
review.
at this stage. You've got to demonstrate a likelihood of success. So what is it that should lead us to conclude that you've got a likelihood of success of being able to prove the religious animus you allege?
Well, Your Honor, for starters, that the president called for a complete ban on the entry of Muslims, and then
is this that ban?
No, we're not saying that this is a complete ban on Muslims entering the country. Obviously, I mean, they realize that I mean, this is well, what his advisor said on television was that he was asked for a way to implement a narrower thing that would be legal. And but the point is that that was clearly a motivating what we have alleged. And again, yes, it is. We do have to show a likelihood of success. But at this stage, the case law is clear. Our plausible allegations are taken as true for assessing that likelihood of success. And
wait a minute, that cannot possibly be true. We are supposed to take your word for it. The fact that you make an allegation of the complaint and that equals likelihood of success, you don't really mean that, do you?
Well, Your Honor, what I mean is that we have assessed, we have alleged.
You can allege anything. Do I have to believe everything you allege and say, well, that must be right? That's not the standard.
You've actually supported these allegations with exhibits, haven't you?
We have supported many of our allegations with exhibits, yes, Judge Friedland, we have, and I do think that's important. We have presented an enormous amount of evidence, especially considering, again, that the time between our filing, our complaint was filed a week ago Monday, together with the temporary restraining order motion, together with the declarations. So unlike cases, we've had extraordinarily little opportunity to actually gather and present evidence in the district court.
We faulted the government for exactly the same thing. Don't tell us you need more time because the government brought the stay motion. Well, don't tell us you need more time. You're the one that sought the temporary restraining order. Either you have the evidence presented in the record or you don't. I mean, don't tell us maybe you'll gather it later. If you can't demonstrate a likelihood of success of what you've got in the record so far, and maybe you can. I'm not saying you can't. But so far, I haven't heard a lot of reference to evidence and a lot more references to allegations, and I don't think allegations cut it at this stage.
Well, Your Honor,
this is Judge if the motion before us is a motion for stay, who has the burden of showing likelihood of success?
At this point, Your Honor, it is the federal defendants who have to show that they are likely to succeed on appeal. We had the burden at the district court of showing a likelihood of success on the merits. But the stay standard is very clear that it's the party seeking the stay that has to show a likelihood of success on appeal. And again, we believe that it would be more appropriate to treat this as a mandamus action where they would have to show a clear and indisputable right to relief. And in part, we think that because if you don't, then it's the district court's temporary restraining order that the federal government is going to maintain is the order to be appealed from ultimately. And that's just not proper, given that in neither form nor substance or intent was that meant to be a preliminary injunction order. It was meant to be a temporary restraining order. The district court was very clear about that. And the district court should have an opportunity to consider the preliminary injunction briefing and issue a preliminary injunction order that could then be reviewed very soon.
Is there more evidence that is necessary, though? I mean, I think most of your claims are going to get de novo review anyway. So I don't know if we really need to wait for the district court to do more unless more evidence is going to be presented.
Our point is not, well, we do intend to file some additional declarations and evidence in the district court if given that opportunity. But I think it's also important to point out, just for fairness, the sake of fairness to the district court itself, the district court should have the opportunity to enter something that it actually thinks is a preliminary injunction order, so that to assess the evidence, to have more time to issue an order that's framed as and intended as a preliminary injunction order that this court could review. And if I guess I'd just ask that if you decide not to do that, if you decide to treat this as a preliminary injunction ruling and a stay motion, then I'd ask you to issue an opinion that treats it like a preliminary injunction ruling and that gives it the sort of consideration that you would want that reviewed with, because the other side, that the federal government has already made very clear that they intend to seek immediate review if this court denies the stay. And of course, you know, it would be unfair to this court and to the district court to have the federal government try to take to the U.S. Supreme Court, you know, an order that was explicitly framed as a temporary restraining order, and that the judge understandably issued urgently.
If we were to issue a reasoned opinion, would that take care of this concern, or is there a concern beyond that?
I think that would address much of the concern, Your Honor. I would ask that you do either one or the other. I mean, I do think it would be better procedurally and more in keeping with the court's precedent to send the case back to the district court to find this temporary restraining order to allow us to put in the evidence that we would to support the preliminary injunction motion and to allow the district court to issue a preliminary injunction ruling. But if you're not going to do that, then I do think a reasoned opinion would do much to address that concern.
Can you tell us whether your further evidence would be more about standing or more about the merits or both?
Your Honor, I think it would be primarily just slightly more detail about standing at this point. Again, we haven't. Of course, the difficulty with a claim that's about intent is that we've made these allegations. We haven't had any discovery yet, and realistically, you know, it will take some time to gather that sort of evidence beyond public statements. And this court has held, and so has the U.S. Supreme Court, that when a case has to do with intent, you know, it's remarkable to have this much evidence of intent without any discovery, I think is probably the best way to characterize it. So I think that the court should keep that in mind in assessing likelihood of success.
We've taken you down to 4 minutes. Is there anything you'd like to conclude with?
Well, Your Honor, the other point, I guess there's one other point I would like to make, that of course we also have a statutory claim under the Immigration and Nationality Act. And we believe that all of our claims are very strong, that we're likely to succeed on all of them, but that is a claim that we feel very likely to succeed on, and that would also potentially allow the court to avoid the constitutional issues if it wanted to by relying on the statutory ground. The INA section, sorry?
But the statutory ground would help us only with regard to those seeking immigrant visas, is that correct?
Yes, Your Honor, I think that is largely correct. I think that is basically correct, that 1152 speaks of immigrant visas and that there cannot be discrimination based on nationality in issuing those visas. And so by extension,
really
that would not seem to help us.
That's not really a way to avoid all your constitutional claims then, right? Because it wouldn't cover everyone?
I suppose that's fair, Your Honor. It would not necessarily allow you to avoid all the constitutional issues, but I guess I just don't want to lose sight of that claim, that it is, we believe it is a very strong claim that the order violates the INA, and also I think it's important I think that's an important point because it goes to what level of deference is owed to the executive. Of course, the president is claiming that he's acting pursuant to a congressional delegation of authority. And our position is, in fact, no, he's acting contrary to what Congress has said. And even if that's not as to every single member, every single person who's harmed by the order, it's an important factor to consider in deciding how much deference to give to the executive on this point.
Well, there have been presidential orders in the past by prior presidents that treated people based on their nation. Why shouldn't that suggest to us that the statute should be harmonized in a way other than the one that you're advocating?
Well, Your Honor, all of those orders have been narrower, significantly narrower than the one here, and included.
The same, though. I mean, if you single out Cubans because they're from Cuba, that's doing it by a class based on nationality. And I haven't heard any citation or reference to a legal challenge to that, or an argument that, I think that one was President Reagan's, that what he did wasn't appropriate. There were others that singled out individual countries. Hadn't been a challenge to that. Why should we decide that Congress, in enacting 1152, since that's the number I've been using, meant to amend or partially repeal 1182?
Well, Your Honor, 2 points. Number one, as you pointed out, there have not been cases about those issues. So there's not. While that may have been to some a much narrower practice than this, I agree that there has been some practice to that effect, much narrower than here. But again, every one of those examples involved much more narrow tailoring than we have here, and also 1182.
But the problem is the same. Can you treat people based on the nation they come from? And foreign policy or foreign affairs do all the time. We treat people from North Korea differently than we treat people from France. So I have trouble understanding your interpretation of 1152 as prohibiting what seems to be commonplace in foreign affairs.
Well, Your Honor, 1182 itself includes a number of exceptions that allow the federal government to deem people inadmissible for security-related reasons and other reasons. But not to make this sort of across-the-board, without exception policy that applies to infants, to school children, to grandmothers, to people who pose no plausible threat whatsoever to this country. So I guess I just ask the court not to lose sight of that statutory claim, especially because I do think it helps drive home that the court can review this order. The court should review this order and should give it the constitutional and statutory scrutiny that it deserves. If the court has no further questions, we would ask that you, first we'd ask that you treat this as a mandamus writ and deny it. But if you're going to treat it as a motion for stay, we'd ask that you deny it and issue a reasoned opinion doing so. Thank you.
Thank you. Mr. Flenge, we let Mr. Purcell go a little bit over, so I'll give you 5 minutes for rebuttal.
Thank you very much, Your Honor. I just want to address a couple quick points. First, DIN. Whatever DIN says about looking at consular decision-making does not suggest that we look behind a national security determination made by the president, where that determination, the four corners of that determination, are explicitly based on the congressional determination that the countries at issue are of concern and does not go beyond that.
You were using DIN and Mandel as your main authority for the unreviewability, and so now you're saying those are distinguishable. I'm a little confused whether you're relying on those cases or not.
We are definitely relying on them for the limits that courts review these types of issues. I'm adding that when you have the document itself, and that is the best evidence of the intent of the president, it relies exclusively on the calls made by Congress and the administration in 2016 about the safety concerns presented by the specific countries at issue. That is the end of the inquiry and should be. In fact, the counsel for the other side cited this court's recent Cardenas decision, and there, in describing the state of the law, the court very clearly said that Congress could have enacted a blanket prohibition on I think it was describing Mandel, on communist aliens, and that is And here we have the president making a categorical determination based on the identification of countries of concern. And there is nothing strange.
You answered the question that was asked earlier about what if the order said no Muslims. And you've been analogizing to cases that were about people who were communists who advocated overthrow of the U.S. government. And are you saying that the external evidence here that is alleged that the intent here was to ban Muslims is equivalent to that?
If there were an executive order that prevented the entry of Muslims, that there would be people withstanding to challenge that, and I think that would raise Establishment Clause, First Amendment issues. But that's not the order we have here. This order is limited to the countries defined by Congress. And let me, on the refugee
point, are that was the motivation, and plaintiffs have submitted evidence that they suggest shows that was the motivation. So why shouldn't the case proceed, perhaps to discovery, to see if that really was the motivation or not?
We're not saying the case shouldn't proceed, but it is extraordinary for a court to enjoin the president's national security determination based on some newspaper articles, and that's what has happened here. That is not that is a very troubling second guessing of the national security decision made by the president. And the notion that we are going to go back into court and
stop. This is Judge Clifton. Do you deny that, in fact, the statements attributed to then candidate Trump and to his political advisors, and most recently Mr. Giuliani, do you deny that those statements were made?
Judge Clifton, no. I would note that Judge Robart himself said that he wasn't going to look at campaign statements. I do, and I think that what
you see, that's a different point. I mean, I understand the argument they shouldn't be given much weight, but when you say we shouldn't be looking at newspaper articles, we're all on the fast track here. Both sides have told us it's moving too fast. Either those kind of statements were made or they're not. Now, if they were made, but they were made not to be a serious policy principle, I can understand that. But if they were made, it is potential evidence. It is a basis for an argument. So I just want to make sure I know what's on the table.
Well, those are in the record, but I think my point is a little narrower, that in the expedited procedure of a TRO, taking this extraordinary action of halting this order that the president determined was in the national security interests of the United States is an unwise course, and it should be stayed.
If we thought there was a problem that this is too preliminary, if we let this go forward to a preliminary injunction hearing, do you have evidence that you would present?
I think we definitely would like the opportunity to present evidence back in the district court, and we also think that the scope of this lawsuit really needs to be.
Can you tell us anything about the type of evidence you would present so that we can consider that whether further proceedings are needed?
Not yet, but I do. Another point is the scope of the suit and the injunction would really need to be narrowed as the parties focus in on the actual harms. The harms that Washington has cited focus on residents of Washington, but the order goes way beyond that to the areas of the most concern of the president, people who have never been to this country yet and have no connection to Washington, no connection to the United States, and no claim of constitutional rights, either on their own or through Washington.
If I can ask my colleagues to indulge me for a moment, that does raise a serious concern on my part, and the scope of the order, most obviously having to do with the lawful permanent residents, which the government's position now is they're not included within the scope of the order. I have to say, is there any legal authority for the counsel of the president to have power to instruct the other departments or to instruct us as to what the order means? I mean, the president can amend the order, but I'm not sure that the counsel of the president has that authority. So why is it we should be looking at this reconceived order, and why is it we should, rather than try to narrowly carve out the injunction you're asking for, and those are practical problems. I don't know how I'd write such an order. Why shouldn't we look to to the executive branch to more clearly define what the order means rather than have to look through the lens of these subsequent interpretations.
Let me make 2 points there. One, the guidance from the White House counsel is the definitive interpretation of the order, and the White House counsel speaks for the president in this context. Second, in our reply brief at the very end on page 11, we had our kind of suggestion for the kind of order that would actually address the harms identified by Washington. And there, I'm going to read that. At most, the injunction should be limited to the class of individuals on whom the state's claims rest. Previously admitted aliens who are temporarily abroad now or who wish to travel and return to the United States in the future. That is the core of the harm they've identified. When we're talking about an injunction entered on such a preliminary basis, it should be limited to the claims that the state is making and not issued more broadly. If there are no further questions, I encourage the court to stay the injunction or to limit it to the presentation of the state of Washington. Thank you.
Thank you, counsel, for your very helpful arguments. This matter is submitted. We appreciate the importance and the time-sensitive nature of this matter and will endeavor to issue our decision as soon as possible. Thank you again for appearing on such short notice. We are adjourned.
This court for this session stands adjourned.
Arguments before the U.S. Circuit Court of Appeals for the Ninth Circuit. A panel of 3 judges you heard questioning lawyers representing the Justice Department as well as Washington State. Hi, everyone. I'm Elaine Quijano. Listening into those arguments as well, our CBSN panel. Here in the studio, I have Ricky Kleeman, CBS News legal analyst, and Carissa Krantz, attorney. Also in Washington, Paula Reed, our CBS News justice reporter, and in Los Angeles, Robert Bamille, former U.S. Senior Deputy District Attorney, now practicing attorney in Southern California. Thank you all. A lot of ground to cover here. And Ricky, let me begin with you. I want to get everyone's take on what stood out most. And this was an hour-long proceeding for people who may have just been tuning in. This was an opportunity for both sides, the government of the United States as well as Washington State, to present their arguments once more in oral fashion to these judges. What, Ricky, do you think was most significant? I know towards the end there you were jotting furiously as one of the judges was questioning the government's attorney.
One of the things that I think stands out is that what you have here is what we would call a hot bench. This is a bench of 3 judges who have really done their homework, who are interested in this case, who know the background of immigration laws, who know the background of cases. And one of the things the public does not understand, who is listening to this and probably reacting on the Twitter sphere, is that this is what judges are supposed to do. They're supposed to ask tough questions, and they want to get to a solution. What stood out for me is really what kept happening in the second half of the argument and ultimately in rebuttal, is that these judges appear to be looking for a way to both either limit the order. They might like it redrafted, but that's not going to be their problem. That's the executive's problem. But also, they're in a question of redundancy. Do we want to go back and go through this all over again for a preliminary injunction, or should we put the whole thing together now? And you have arguments from both sides trying to figure out which way the judges really want to go here. Do we go back to court? It's still fast-tracked in the district court, or do we try to dispose of it now?
What about you, Carissa? What stood out? And also, did you get a sense that there was more skepticism coming from the judges towards Washington State, that attorney, the Solicitor General, or towards the Department of Justice attorney? Could you suss that out at all? Because it seemed there was vigorous questioning of both sides.
It's very normal for oral argument at a court. Like, what the viewers might see is what's going on. There's a whole bunch of legalese going back and forth. The lawyers are talking a bunch of legal mumbo jumbo, and then the judges are jumping in with these complicated questions that might throw the lawyers into a tailspin on how they may or may not want to answer it. That is one of the things about oral argument that is unpredictable. You never know what's going to happen. You can go there with a speech written on what you want to say, and judges are going to jump in because they're going to want to be able to analyze something and write an opinion that's well thought out. The Ninth Circuit is a traditionally liberal circuit. I would not be surprised at all if they uphold the stay on the travel ban and allow the district court and defer to the district court to continue their briefing on the preliminary injunction, which is supposed to be finished, I believe, next week or February 17th. And then today was more, even though we got into the merits at oral argument, it was not really supposed to be about the merits. Today is whether or not, the executive order is going to stand while the merits are well thought out in the legal process, which could take time and travel all the way up to the U.S. Supreme Court. So, a lot of things can still happen.
Yeah. So, Paula, let me turn to you then. What stood out to you? I know you have been explaining this to us here for days leading up to this. For folks watching at home, the bottom line is, for now, no decision, right?
That's right. We don't expect a decision tonight. We also would expect something by the end of the week, hopefully. But what really stood out to me is how the Department of Justice in the first half of that, their representative, he struggled a bit. And it's important to put that in the full context of what is going on at the Department of Justice right now. They do not have a confirmed attorney general. They have an acting attorney general. They're missing a lot of important staff people there. The Department of Justice was not consulted, nor did they have input on how this order was actually drafted. And then just a few days ago, we confirmed that the acting solicitor general and the acting assistant attorney general, who had been so instrumental in arguing this case, they had to back off of their case because of a conflict of interest with their prior law firm, Jones Day. So that's why the lawyer who was sent to argue this on behalf of the Department of Justice, he was at a bit of a disadvantage, but I do think he was able to get his point across. The key to their argument is that this executive order was within the president's power, that it's a temporary pause, and that the court upset this balance that the president was trying to strike between greeting people warmly into this country, but also protecting our national security. And finally, and most importantly, they argue that this temporary restraining order is overly broad and therefore should be lifted.
Ron, let me turn to you. You have argued before the Ninth Circuit. Tell me what stood out to you. And also, do you agree with Paula's assessment that at times it seemed as though the Justice Department's attorney may have struggled a bit?
I think he was a train wreck, actually. I felt sorry for the
train
guy.
wreck, okay.
Train wreck, yes, as in disaster. When you have 30 minutes to argue and you spend 15 minutes stuttering, that's not a good day at the courthouse. I could tell initially that, and also the other thing that we don't know of, and because we don't have eyes in the room, at least I didn't, is the atmosphere in the room. And I think when he stood up, he had a good idea. It wasn't going with him. Judge Friedland is completely anti the government. You could see that in her questioning and the way she questioned both sides. I thought it was clear that she has pretty much decided the case for herself. So I would disagree with anybody who would say differently. Now, the voices I had trouble distinguishing was Canby and Clifton. One of them appears to be siding with the government. The other one seems to be siding with the state of Washington. I believe that the decision will come down about Thursday. It's going to be against the executive order. They're either going to send it back to the district court for further hearings. But I don't believe there's going to be overturning of the stay at this point, overturning of the temporary restraining order at this point.
And so, Carissa, let me turn to you. What happens now, you think, as based on some of the questions that we heard from these judges and the vigorous line of questioning that they were pursuing in some instances, not just questioning the U.S. government, but also the attorney for Washington State as well on these complex legal points, but essentially what I took away from it was a lack of clarity in the executive order seems to have left these judges wondering about the best way now to approach clarity. And should that be something the judges should do, or is that something that is on the executive branch? Can you help us understand that?
Sure. The basis that the executive orders such as this one should be interpreted would be a rational basis review, right? So you can't have a ban against the Muslims, you can't have a ban against a country's origin or a religion, but you can have a ban if national security is at risk. So they're going to be determining whether or not the merits are weighed in favor of immigration interests or national security interests. Going forward, we don't really know how they're going to come down. They probably are going to send it back to the district court. There's deference to the district court, allow them to consider the preliminary injunction briefing. And then it would be rational, I mean, you have a rational basis review, it would be rational for the president and Congress and the powers that are vested within the president for national security and foreign policy, it would make sense for them to redraft the order so there wouldn't be all these concerns. However, it doesn't seem like they want to do that. It seems like they want to go forward and, execute their right to have these executive orders and let the courts, argue and take it all the way through the process. It seems that Trump's administration believes that they have a strong argument that they can win this. And, but it does seem that the executive order probably should be redrafted because there are exceptions that now they're verbally carving out, but it's not written. And now we're supposed to just trust.
In the green card, the case of people who are green card holders, et cetera. Right.
So we're supposed to trust on goodwill now that the exceptions are going to be carved out based on verbal exceptions, and how is that going to be enforced? It would make sense that they would redraft this during this day and then have an executive order that made more sense, that wouldn't unleash the chaos that that sent the media into a frenzy.
Yeah. Paula, what about you? What do you think about that? It was interesting at one point, I think it was Judge Canby asked the Justice Department attorney, what if President Trump said simply, we're not going to let any Muslims in? Could he do that? So is there going to be, you think, and I'm asking you to kind of speculate a little bit, but based on the performance of the attorney representing the Justice Department, based on the lack of clarity that we know has existed with this executive order in the rollout of it, you think there will be, in fact, an effort now to present an updated or a modified executive order to try and answer some of these questions that have been raised during these oral arguments?
Well, it's one thing I've learned in the past few weeks. It's just never try to guess what the Trump administration is going to do. Now, I agree that one of the most easy solutions here is to go back to the table, get more input from the Department of Homeland Security, get more input from your Attorney General once he's confirmed, make some carve-outs, draft this in a way that anticipates Supreme Court review, because the way it is drafted right now, in addition to the rollout and not really consulting Congress, is so problematic. And part of the reason that even just at this initial stage, they're already so embroiled in litigation. So absolutely, I think redrafting this would be a very smart way to avoid just becoming embroiled in litigation. But so far, it seems that they're willing to litigate this, every little piece of it, every step of the way. So it doesn't seem that's the path they're going to take. But we'll see what happens when presumed Attorney General Jeff Sessions is confirmed. He may step in and perhaps take over a little bit more, because as this was drafted, we know that the head of the Department of Homeland Security was not actually consulted. He got to see some drafts, but he did not get to have input, nor did an attorney general, because the acting attorney general at the time said she wouldn't enforce it. She said it was bad policy, and as we all know, she was fired for that.
All right, Ron, I'll let you have the last word. We only have about a minute or so left, but you think next steps in this process, what do you think we can expect now?
Well, the problem the president has is, I wouldn't roll back anything, by the way. I wouldn't change the executive order at all. I'd go forward this way. That's what they've said they were going to do. So I would go forward with it, because they're going to lose, unless, of course, that he gets his justice on the Supreme Court and he switches the forum to his favor. At this point, the forums are against him. They're not for him. So he's going to have a great difficulty in getting this upheld. However, even if it's rejected, even if it dies there's nothing preventing him from drafting the next executive order to implement slightly different and imply that and try to get that before a forum that would be more favorable to him.
All right. My thanks to my panel, Ricky Kleeman, Carissa Krantz, Paula Reed, and Ron Bamille. Thank you all so much for your insight. Appreciate it.
Thank you.
Thank you.